Justice Crane, we elect judges in Louisiana, do we not?
We do.
And we have elected judges, our people have decided to elect judges for a long, long, long time, haven't they?
As long as I can research, yes.
Are you responsible for that system of choosing judges?
Not at all.
When you run for judge, can you solicit campaign contributions?
You cannot.
You've run 3 times.
I have.
Have you ever solicited a campaign contribution?
I have not.
You have to go through a committee, do you not?
That's correct.
Okay. Now, one of my colleagues, not Senator Welch, suggested that you live in the left front pocket of the oil and gas industry. Is that true?
That is absolutely not true, Senator.
Hello, everyone. Welcome back to the channel. If you're new here, I'm your independent political analyst. No spin, no hype, no tribal loyalty. Today, we're reacting to a Senate Judiciary Committee exchange featuring Senator John Kennedy of Louisiana, Justice Crane, and Prosecutor Mr. Duva. This moment touches on judicial elections, prosecutorial ethics, and something increasingly discussed in today's politics, lawfare. Let's break it down.
Senator.
Do you live in anybody's left front pocket?
The only pocket I live in is the rule of law, Senator. And I think that my record reflects that.
That's certainly been my experience. I just wanted to clear that up.
Thank you, Senator.
Mr. Duva, you've heard the expression lawfare, have you not?
Yes, sir.
What does that mean to you?
Well, I think lawfare gets to the alleged weaponization of the Justice Department and things.
What does that mean?
Well, it's a term that's been used quite a bit. I think it means that the Justice Department becomes the tool of a sitting president or the Congress or whoever to do its bidding and that only, and not follow the law, not follow the facts as applied to the law. What we will do is not do that. We will do the converse of that.
Why is that dangerous?
Because it leads to bias, it leads to improper prosecution, it leads to messes in courtrooms. There's a reason there's a justice manual. There's a reason that there is Rule 6E.
I don't want to talk about the manual. I want to talk about just basic human decency and common sense.
It also erodes the faith of the justice system and our citizens.
Okay.
That is dangerous because it is based on those citizens where the end result, the citizens become jurors. And we need jurors to have confidence in the Justice Department and the prosecutions that it brings and to fairly evaluate cases.
Let me put it this way. Our judicial branch doesn't have an army, does it?
It does not.
Okay. Our judicial branch at the federal and the state level depends on its legitimacy for enforcement. I mean, people have to believe that justice, even though they may disagree with the result, people have to believe in the integrity of the system, do they not?
They do, because as I mentioned with jurors, if they don't and they're selected on a jury, they're not going to follow the judge's instructions to evaluate the cases based on the facts and the law. So it depends on the citizens to help us with the end result. And if that's eroded on the front end, it's eroded on the back end.
All right. If I'm a candidate for district attorney, is that a principle that you agree with?
100%.
Okay. And you not only have to believe that the defendant is guilty, you have to believe that you can prove it beyond a reasonable doubt, do you not?
You do. You have to have the facts. Without the facts, you have nothing.
Okay. Is that a principle that you possess?
I do, and that's how I've operated for 18 years.
Okay. And you also have to believe, do you not, that the prosecution is in the public interest? Is that correct?
You do.
Okay. Now, if one of your superiors came to you Well, let me answer the question for you for how I would do it. If one of my superiors came to me and said, look, you got to prosecute this case, and I looked at it, and either I didn't believe that the defendant was guilty, or I didn't believe I could prove it beyond a reasonable doubt, or I thought it was not in the public interest because it would undermine the integrity of the criminal justice system, I would resign.
You would,
Is-
decline the matter.
Sir?
You would decline the matter for sure.
Right. And if they told me, if my superior said, look, Kennedy, you know, what planet did you just parachute in from? You don't have a choice. I'm your boss. I'm telling you to do it. I would resign. How about you?
I have no problem doing that. I would first just say, we're not doing this case, and here's all the reasons, and the discussion could go from there.
Okay. And if you were told to do it or quit, what would you do?
I'd quit.
Okay. Would you ever advise a client not to follow a federal court order?
No, sir.
I appreciate that. Appreciate you not qualifying it. If it's okay to disagree with a federal judge ruling, isn't it?
I often have.
Yep. It's okay to appeal it
Absolutely. We have an appellate section. It's one of the best sections in the criminal division.
within the bounds of legal ethics. It's okay to criticize it, isn't it?
Yes, internally.
But you got to follow it, don't you?
You do, absolutely.
Because that's called the rule of law, isn't it?
It is, and without that, you have anarchy and no confidence in the Justice Department.
I appreciate it, and I appreciate the frank answers.
Senator
Thank you,
John
sir.
Kennedy begins by asking Justice Crane to confirm that judges in Louisiana are elected by the people, a system that's been in place for a long time. Crane confirms that as far back as she can research, that's how it's been done. This is important context because judicial elections aren't universal. Some states appoint judges. Elections add democratic accountability, but can introduce political pressure. Kennedy highlights a key safeguard. Judicial candidates cannot personally solicit campaign donations. Crane says she has never done so across 3 campaigns, relying instead on committees. That's an important ethical boundary designed to protect public trust. Kennedy then addresses an accusation from another senator, not Peter Welch, that Crane is somehow in the left front pocket of the oil and gas industry, a colorful Louisiana-style metaphor suggesting undue influence. Crane rejects that completely, saying the only pocket she lives in is the rule of law. Kennedy essentially clears the air. Moments like this test nominees' credibility, especially in states where energy interests are politically powerful. Whether you trust her depends on performance and record, not sound bites. Next, Kennedy turns to Mr. Duva and asks whether he's heard the term lawfare. Duva describes it as a weaponization of the Justice Department to serve political agendas rather than facts and law. Kennedy presses on why that's dangerous, and he's right too. Lawfare erodes public trust in prosecutors. Once the public sees the legal system as partisan, the legitimacy of verdicts begins to collapse. And in a rule of law society, legitimacy is everything. Kennedy makes a powerful constitutional point. The judiciary doesn't have an army. That's not just clever rhetoric. Courts rely on voluntary obedience and the belief that laws are applied fairly. When trust erodes, citizens stop respecting decisions. Jurors ignore instructions. Court orders go unenforced. The system fractures. That's why political weaponization, real or perceived, is so dangerous. Kennedy then outlines the ethical standard for prosecution. You must believe the defendant is guilty. You must believe you can prove it beyond a reasonable doubt. And the case must serve the public interest. Duva agrees, saying he's operated that way for 18 years. This matters. Prosecutors are not supposed to win at all costs. They act on behalf of justice, not their boss, not their party. Kennedy asks a hypothetical. If a superior demands you prosecute a case you believe is unjust, what would you do? He says he'd resign. Duva responds similarly. He would decline, and if forced, he'd quit. That's a strong public commitment to legal integrity. In reality, such pressure happens more often than we hear publicly. So these answers carry weight. Finally, Kennedy asks whether Duva would ever advise a client to ignore a federal court order. Duva says absolutely not. Kennedy emphasizes, you can disagree, you can criticize, you can appeal, but you must comply. That's the essence of the rule of law. Without compliance, you get selective obedience, and eventually, anarchy. Here's my neutral analysis. Senator John Kennedy's questioning highlights something bigger than party politics. It reminds us that the justice system depends on ethics, independence, and public trust, not force. Whether you agree with Kennedy or not, the principles at stake, integrity, restraint, legitimacy, are foundational to any functioning democracy. Thanks for watching. If you found this breakdown helpful, hit that like button, subscribe for more independent political analysis, and comment below. Do you think public trust in the justice system is improving or declining? As always, stay informed, stay curious, and stay independent.